is intellectual property? How do I protect it? And if I don't, can someone come in and steal my ideas? Those are the things we're going to be talking about today with esteemed lawyer Craig Kaiser, a good friend and also a former client. But before we get to that, I don't know about you guys, let me know, but that new music, way better for me. I was digging it, the old little classic rock bent on it. I know Craig's a bit of a music guy too, but I think he's more on the classical side. I'll have to see what he thinks of the new music. If you're watching us on the live stream or YouTube, or you're listening to this on the podcast, don't forget to follow us or subscribe or like us, or you could follow us, or you could like us, or you can subscribe with us. Whatever platform you're watching on this, make sure you're subscribing, getting connected with us. We're posting these twice a month. There's lots of content coming out. We don't want you to miss out. This podcast and live stream is all about informing small business owners, $5 to $25 million a year, giving them advice they might not normally have access to, or heck, even think about. So today's a great show. We're talking about intellectual property. I ran into Craig. He's an old friend. I think we met, man. Craig, when you come on, you'll have to remind me. I know we met through Vistage, but I forget how we actually finally connected. But it was a couple years ago. I had the great fortune of working on a super interesting project with his law firm, Phillips Kaiser, and ran into him at a networking event not long ago. And I was like, man, we should really get you on the podcast, on the live stream. And we kind of brainstorm ideas. And he was like, intellectual property is a big one for people. So I thought that is great. Let's do it. So without further ado, let's bring on Craig Kaiser from Phillips Kaiser. Hey, buddy.
Hey, how are you doing, Corey?
Good. How are you?
Good. I love the music.
That was the first question, the most important question.
Yeah, and it was very professional, and the graphics and all that. I loved it.
You like it? Did it have I was like toe tapping and drumming on the desk. Awesome. So do you remember we met through Vistage as a whole that we met, but I think we kind of just connected, went for lunch and.
Well, yeah, I think Brian Leisinger.
Well, there you go.
Was the guy that connected us, and we hit it off as kind of kindred views about the business world and the businesses we were in, and it was a pretty easy fit. Yeah,
very cool. And we have a lot of synergies because Phillips Kaiser, you guys are have that outsourced legal model and outsourced general counsel, right?
Yeah.
And we kind of deal in the same client base.
Yeah. And I'm not getting paid for this plug, but I will say, yes, you did help us on a project. We were a client of yours, and you did a great job of kind of helping us in thinking about who we were trying to hire in that project, and then went out and found that person. So, yeah, I know that's not part of the program, but you'll let me do that, right?
I'll take it. I have no problem with it. Cool. So we'll let you plug Phillips Kaiser a bit at the end, but let's jump into this. People don't want to hear us reminisce, so let's talk about this intellectual property. So question number one, what the heck is intellectual property? How should I be looking at this as a business owner?
Yeah. So, I'm not gonna. This is not going to be like black letter law that can be pretty boring even to lawyers. But let me start by give us a little bit so that we sort of know the parameters of when we say intellectual property. All right. So intellectual property is in a company a value that is sometimes it's intrinsic, or it's a developed ideas kind of a thing. Okay. And there are 4 distinct categories. One has a subpart, but we'll stick with the 4. And so I will give very quick little definitions. And some of them pretty well, the listeners will. And some I think you don't. So the first one is trademark. And everybody knows a trademark is, something that's on a product. The definition, a simple definition is it's the right to use and exclude others from using a specific name or symbol as an indicator of source of origin or sponsorship for goods, or services. So example would be the Coca-Cola brand, right? And the way it looks, and, with the stylized C's that swoop, but then it can also just be the name. So it can be design, or it can be the name itself. The other thing about trademark, you can also trademark things sometimes like shapes, like the bottle of the Coca-Cola bottle, the classic one that curves, and that design, or like a furniture design might be trademarked. Okay, that's something you could do. Colors can be trademarked in certain instances. UPS has brown trademark for trucks on delivery. So interesting. So that's trademark. Second one, copyright. And you think about that. You think about music is copyrighted. Software is another one that's a lot. But it's interesting to note there that source. So you can, when you copyright, you protect the expression of it. So you can protect source code, but I can't protect how how it appears on the screen. Somebody else can go recreate that. They just can't use my source code to do it. But that's a second one is copyright. A third one is patents. And everybody, when they think of IP, they always say, oh, patents. I came up with an idea, I file a patent, it protects it from anybody using it. And it is a right for a limited time to exclude others from using that.
Patents have they have a life cycle, correct? And then they become open to others. Is that correct?
Yeah. So, and I guess I'll jump back and say a trademark, you file, you have to renew it every 10 years. You can keep it forever so long as it qualifies. You're renewing it. Copyrights last for the author's life plus 70 years.
Plus 70?
70. Yeah.
Okay.
Interesting little sidelight on that. The Congress extended that like every 5 years for a long period of time. And the reason was every time Mickey Mouse came up for expiring, the Disney lobby would lobby Congress to extend the period for copyright to keep that very valuable asset, Mickey Mouse, from going into public domain. So patents go 20 years from filing. And then the last one is a trade secret. And that's one I think we ought to spend a moment on today. Okay. Trade secret is right to use it and exclude others from using it. And there's no filing involved. You have to keep it secret, and it has to have economic value to you, the owner. And that's really it. But so it sounds like, well, it sounds kind of weak. It's actually can be very strong. In fact, I should say, we were talking about Coca-Cola. Their most valuable asset is the formula, and it's a trade secret, and they keep it very famously secret. And so that has no expiration so long as it remains secret.
And so you would protect that with like NDAs?
NDAs are a key element. You control it. You protect it by access. Who gets to see it? Do they have a reason to see it? If somebody leaves the company that had that access, you make sure you let them know, and their future employer know that, hey, he knows information that's our company owns, and if you're really nervous, you might tell them we expect him to respect that, and you as the company to respect that.
So I think what I'm hearing is there's a collection of activities you need to take to show that you were trying to keep it. You were doing everything you could to keep it secret, and all of those activities as a whole are what make it a trade secret and protect it.
That's right. And that it's valuable, so you can't just make up things, but yeah, it has to have a value. That's the definition. But yes, you're right. It's process more than anything else about trade secret.
So you can't file for a trade secret.
No. In fact, so I will say the difference, patents, for example, you're telling the world what it is. You're filing it with the patent office. If I wanted to develop my own patent, I can go out there and see who's done what, and I have to design around it. So that's known. This has to be kept secret, and nobody sees what you're doing.
And I guess, you wouldn't patent the Coca-Cola recipe because after 20 years, it becomes public domain.
Absolutely. Or that's probably the biggest reason. And then the other is if somebody can actually see the recipe, well, they can tweak around it a lot easier, as opposed,
Right.
I'm sure they know what the general ingredients are, but they don't know the recipe,
Got it.
Yeah.
Okay. And so as I'm hearing this, especially the, what was the last one called again? It escapes my mind.
Trade secret.
Trade secrets. If I had a software company, or I'm just trying to think as a business owner, or I had a process that I was selling to someone, keeping that a trade secret might be advantageous rather than trying to protect it with a patent or a trademark.
Yeah, and yes, and it's a lot easier and less expensive to do. For everything's not patentable, but everything you find valuable that's secret and you can define that as trade secret.
But it sounds to me like you need to be more consistent and diligent around a trade secret. You can't just all of a sudden say, well, that was a trade secret. And they say, well, how did you try to protect it? Well, I told them not to tell anyone. That probably wouldn't carry a lot of weight.
That's exactly right. You won't win that. You will not, when you sue them for misuse of your trade secret, you will lose that case because it comes down to show me the steps that you take to protect that from being disclosed. And if you don't have a good, tight record there.
Documented, I'm guessing.
Documented for sure. Yeah. But I say that, yes, but it also is not, this is something any company can do. The smallest company can do that. Right. So it's not onerous, but it needs to be intentional and held to, rigorously.
Okay. So what, in your experience, are the kind of mistakes, the biggest mistakes that a business owner might make around intellectual property?
So the biggest one, and I think when we talked about what would we talk about on this is it right here. The biggest mistake is small business owners think, well, I don't have any intellectual property. That's the biggest mistake. They think I'm not creating, new designs for engines or any, they think patents. And everybody should have some level of trade secrets. So, Corey, whatever you're doing in your, what's your approach to pricing, to getting customers, to, your vendor list, to, your 5 steps of engaging with a customer, any of those kinds of things that create strategic advantage for you that make KeyHire. This is something I can go in and sell, that's a trade secret. And you should really consider protecting that. If not one of the other ways, but that's the biggest error, I think, right there.
And so I totally get that one, but might there be some other ones out there that people would be surprised about?
Another big mistake would be when you have employees developing things as a part of their business.
Sure. Yeah. This is always an interesting conversation, right? Because they go, well, I created it, but I was paying you to create it.
But each is a little different, but in copyright, the person who created it by common law owns it, unless you have a contract. It's called a works made for hire in copyright that expressly says, if I've hired by you, and if I do this kind of work, blah, 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 the company's going to own it. Patents too. In a patent, the developer may be an owner of it, and the employer would have a right to use it, but they're not the owner of it that could go sell it to somebody else, unless you have an agreement in place up front that says that the company's going to own that. And that doesn't just apply to employees either. That applies to contractors that do work for you as well.
So this raises a really important question, because I'm sure a lot of people are thinking, well, we have an employment agreement. So that clearly says you're working for me and I'm paying you to do this work on my behalf. That's what you would think.
Yeah.
What I think I'm hearing is that's not enough.
Right. You need it needs to have an express conveyance of any IP that's developed. That if IP that's developed will be owned by the company, and that agreement also says that the employee will assist in anything that needs to be filed, because sometimes as an inventor on the patent, for example, they may need to sign off on documentation for that. So the agreement includes that kind of language in it.
Okay, so now I think that's incredibly valuable on its own, but is there a way, if you're hiring an engineer or a chemist or a something, to include, does this need to be done on a project basis, or can we include this form? I'm a small business owner and I'm hiring an engineer to work on an electrical widget for my, as one of my clients would say, Daryl, my flex capacitor, right? And so can I include a document in my hire package that they would sign off that would cover me off on that? Or do I need to take care of this on a project by project basis?
No, it can cover the full engagement, and it can be right off in the initial sign on with the employee. And it doesn't, you don't need to have a full employment contract. Sometimes people don't want that, but you do need that IP assignment. That is an agreement that needs to be signed. And you make a good point too, Corey. It gets much trickier if you don't do it at the time of hiring, because so let's say once I've hired you and you're doing work for me, and a year later I go, oh, I need to get him to sign that. All right. So I can't slide that under your nose and say, now sign this, because a contract has to have mutual consideration. I give something of value to you and you to me. And you're already, if I do it at the beginning, it's considered a part of the hiring of you. In exchange for a job, you get that. But so what you have to do, and it's not as clean, but one thing you can do is, if you are, let's say you are giving bonuses or something, you might tie that in with a bonus, an annual bonus or something. But you need to try to dress it up somehow to look like, no, there is consideration here for me having them sign that agreement.
So am I hearing you? There needs to be something other than, hey, this is part of your job. I'm paying you a weekly or biweekly salary to do this. But if you give them a special task, I need you to create something new that will become part of our IP. Upon completion, you will get a $5,000 bonus. Or once we make filings for whatever we're going to do with it, or the patent is approved, you would receive something in addition for that work.
Okay, no, let me clarify. I didn't say that well.
I didn't hear it very well. Either way,
but this is an important distinction. All right. So all I'm saying is, if you have them sign it when they initially hire on, you don't have to pay them extra for that. Okay. It's just employment is enough. I'm giving you employment.
Right.
All right. Now, what I'm saying is, and even if their job changes down the road in your company and they weren't doing design work and now they are, as long as they signed that at the front end, you're fine.
Okay.
But if you didn't do that, and let's say a year later you realize, I should have had, this guy's doing things, or I talked to a lawyer and he tells me I should have, I don't own these things unless I get this assignment. I need to get them to sign it. All right. If you do that, now you can no longer say it's about employment. Now you have to give an additional something.
You have to tie it to an incentive or performance or an incentive.
To sign it. Yeah. Okay. That's all.
And is it, So I just want to walk through a couple different scenarios because so would it be if you sign this, I'll give you money, or if you sign this when it's complete, you will have earned an incentive, or does it matter?
It's really, I think it's really atmospherics a little bit. It's sort of like I'm gonna, we're giving you this.
Oh, Matt, Craig froze up on us. Matt, are we still going? Matt, can you hear me? Oh, Craig, you're back. You froze up a bit on us there.
Okay.
You were saying it was atmospheric.
Yeah. All I'm saying is there does need to be a sense of quid pro quo. Okay. It does need to tie your signing to this bonus. Okay.
So it doesn't matter when they get that bonus. You could structure it however. There's a million different ways to structure that incentive.
Yeah. It just needs to be a value that makes sense. $50 probably doesn't make it. But if if you pay them 5,000 or 1,000 or whatever's, significant in that space.
And it probably would depend on the scope of the work they're doing as well. Man, we are having some connection issues. Hopefully you'll come on back here, Craig. So just kind of what I'm hearing from Craig while we're waiting for him to come back is, when you're getting them to sign off on this document, which seems super important to me, is if you don't get it done at the initial startup, which it sounds to me, and once we get Craig back, it'll be good to get him to confirm or not, but to have something in your startup package, in your offering that says, hey, anything you create while you're working for us will be the property of our company. And then you can cover yourself up a bit. But if you haven't done that in the past, you're going to need to go back and present this to them, but it can't be under duress. You can't say, hey, I need you to sign this now, even though you're halfway through the project, or you've completed the project and you've created something super important to my business. Now I need it. And you almost kind of have to come to a negotiation. Probably would be easier if it's not completed yet, so they don't understand the value of what it is. But if you have information that is in work, in progress, you probably want to make an arrangement so you own that IP when all is said and done. Now, I don't know if this is my connection or not. Matt, do you have any idea if it's coming from my end or Craig's end or where it's coming from? No, huh? Okay, well, we're still waiting for Craig to get dialed back in here. So super interesting. We'll have to, hopefully we can get him back on to wrap this up. But if we don't, Craig, I see him back here. Is he there? Hey, did you hear my summary by any chance?
No.
Okay, so what I was saying is, it sounds like a great idea to include in your hire package a document that just says anything you create while you're working for us is property of the company.
Yeah.
And they can call you to get you to create that document.
Yeah, because it's not some huge document, but there are sort of some terms of art to it that ought to be in there. Yeah. But
and
yes,
secondly, if I have some stuff people are creating for me and it's work in progress, I need to be going to those people and saying, hey, I just figured out I should probably have you do this. Let's kind of come to terms on what it would be. And my thought was, if they've already completed the product and they can see the value of the product to your business, getting them to sign the rights away to that will probably be more expensive after they understand the value compared to while they're creating it and they're not thinking of that, right? Once it's done, you say, great, now I need it. And I'll give you $5,000. And they say, you're going to make millions off this thing, right?
Yeah.
So earlier is better. And what do we do once we get to that end point where you're like, maybe there's some people watching and they're like, oh shit.
Yeah. I've had this happen a few times and And I do think you've got to think through it in each case. Like, you don't, I think a lot of times employees are just as clueless on this as employers. And
But
so
as
I
soon
don't,
as you come to them and say, oh, by the way, I need you to sign the rights of that over, they're going to get curious.
yeah. And so I do think, I do think, but a lot of times I think they think the employer owns it. And I think sometimes I would come at it a little bit with a tone of, we need to do some corporate cleanup as a part of our business. And one of them is, I've got to get a clear statement that what we paid you for, we own. And, I come at it that way with that kind of language, as opposed to,
Framing.
gee, you really own this, because everybody knows we were doing this, in a way that we would own it. Now, depending on how valuable it is, a lot of times it doesn't seem that valuable, in the front end. You might just, like I say, give them a bonus and you take it. If it's some super valuable thing, maybe you say, hey, look, for the stuff you've developed, we'll do a percentage, or, this is where I think it gets pretty specific if you have to start cutting a deal.
It sounds like that would be a fairly sophisticated product or widget that you would have created at that point, right?
Yeah. And you might have a designer there, or somebody who is a little more aware of what their rights are. Yeah.
So what I'm hearing is, the further along the process these people are to creating IP for your company, the more there's a need to reach out to a guy like you to say, I might be in a bit of a pickle here. What's the best way to maneuver this?
Yeah. And yes, I think that's right. And I would say, even if you don't think you've got a lot of IP that's been generated, that might be a better time to go ahead and, if you need to get control of what's being developed in your shop, do it before it's generated.
I think just right at startup, you should just include, if you're running any type of business, you should just have a form in your startup package that says, hey, anything you create while you're here is
Yeah.
Okay, so here I am. I'm a small business owner. I'm listening to this. I'm having multiple heart attacks, thinking, "Oh God, I missed out on this." What do I do? What's my first step to kind of cleaning up my backyard and making sure I own? First step I make to start protecting what should be mine?
Yeah. So first step is take stock of what you think your intellectual property is. Okay. And what does that mean? It generally means, what is it that is of value in my business? Is it my brand? Is it the stuff we're creating on the shop floor? All these things we talked about. What is valuable? And sometimes the way to think about that is, what if I sell this? My intent is to sell this company in 5 years or 10 years or whatever. Who would buy that, and what will they value in it? Because, and that serves several functions, not the least of which is IP. But if you sometimes you'll see people who build a business and they build it around themselves and their super ability to sell, and they have all the relationships. Well, that's a hard business to sell, because I got to go with it. And what you really want to do is sell it to somebody. You take it and you go, pay me for it. IP is a great way to enhance value that you can transfer. Okay. So if you keep those things trade secret, that somebody values, like, this is why this company is good to have. It's got a very valuable trademark. It's got, great brand recognition. Then that's a first step. What is valuable here? Okay. And then that helps you also focus sometimes in your business and get away from, I'm just trying to sell as many of these as I can, and really, okay, the real value in this business is this. And so I really need to continue to develop in those areas. So what's valuable to you is a first step.
As you were saying that, I had this vision of Shark Tank, right? Like, because people are selling these great business and they're like, do you have a patent? No, it's not our technology. I'm out.
Yeah.
Right? We're leasing the technology. But when people say, yes, it's patented, they're like, okay, because now we can license and do all kinds of different things. So it kind of shows whether it's real world or not, I don't know. But
No.
it's just the value of owning your IP.
That is so right, Corey. So it's identifying it and then documenting it, protecting it. So depending on the type of IP, does it slip? I mean, do you go get a patent or two? Patents are kind of expensive, but for small companies, the fees are reduced. But that's if it's a good patent, it's super valuable. You know,
and if you're making one specialized product and you're the only one who can do it or knows how to do it, it makes sense, right?
Yeah. Or it might be of some value to you, but to a bigger company that could use that in what they're trying to do in their much bigger business, it may be way more valuable to them than it is in your little business. So documenting, we talked about trade secret process documentation, whatever, that is what you need. So when that buyer comes along for your business, you can say, this is what I own. And this is this is how I define my trade secret. These are my patents. This is I have rights from all the employees. You've got that documentation. That's what you need to do. So identify it, document it.
Cool. And the one thing I wanted to ask you that I kind of didn't, but is, if I don't protect my IP, can someone take it and protect it under their name?
Absolutely. Yeah. I mean, now it's a little more complicated answer than that, but the bottom line is, if you don't protect it, you don't really, your rights are limited. Now, like in trademarks, there's a common law. If you start using it, like you use KeyHire, it may be, you have that right in it. So far in the space you're in, the location, but if somebody else is using it, and they file with the Patent and Trademark Office, you've got a real problem. So, but there are some rights without filing in some instances, but I would not take comfort in that in any of these areas. Well, patents, trademarks, and copyrights. You need to protect it by filing.
So, Craig, if I'm a business owner and I'm thinking, okay, first things first, I need to include a document in my startup package that says anything created on for the company is owned by the company, or I have people working on projects and I need to have conversations with them, or I have people that have created something for me that's completed and I need to figure out how I can reel that back in. How do I reach you and get in touch with you to have those conversations?
Okay. I need to make sure in that employment agreement you talked about, you need to have a requirement of confidentiality that protects your trade secrets, right? So an employee is bound to hold in confidence things that they're exposed to. All right.
See, that's why they need to reach out to you.
Yeah. So, all right. So can reach me at, my law firm is Phillips Kaiser, and that's PHILLIPS.
This is where we put Matt to the test. Let's see.
Oh, good. He could put it up. Okay.
Let's see if he can flash it up. Let's go, Matt. Hey.
There you go. Okay. So ckaiser at phillipskaiser.com, or my number 713-955-2742.
Give the number one more time.
713-955-2742.
Come on, Matt.
He's got to follow the numbers.
There you go. Good. Email anyway.
That's good enough. That's good right there. That gets it.
Kaiser at phillipskaiser.com. Awesome, man. We ran over, but this is, I got to think this has been super. I've learned a ton. That's why I love doing these. But as a business owner, if I was listening to this today, I would want to be reaching out to you and saying, I need help.
Yeah. No, that's great. I appreciate and I apologize for the dropping out. That's no fun.
Oh, well, what can you do? Hey, man, thank you so much. Great having you on here. Thanks for your time. I really appreciate you carving out some time to spend with us.
Thanks a lot, Corey. I appreciate it.
All right. Thanks, Craig.
All right.
Man, that was awesome. So much good information. I've had those conversations with them before too, but never that broad and kind of trying to get that understanding. So if you are a small business owner, you need more information than that, absolutely reach out to Craig. Best guy. He'll take the time and walk you through it. And what you see is what you get with him. So what you saw in this is exactly the way he'll deal with you professionally as well. He's a total pro. Before we sign off, like, subscribe, share, be a part of the community, help us spread the word. We're trying to do good work for small business owners, and any of your help would be appreciated. You can always, if you have questions about your own talent strategies or hiring or constraints within the business or operational deficiencies, you can schedule a consultation and we're happy to walk you through any of that good stuff. No weirdness, no sales, just help. We're a help first organization. We have a YouTube channel. Oh, we got podcasts. So our podcasts go out on alternate weeks from the live stream. So you can listen to us on all the major streaming providers: Spotify, Apple, Amazon, Google, Audible, KeyHire Solutions, Small Business Podcast. What else we got, Matt? YouTube. Oh, ebook. We got an ebook on how to build your hiring and interviewing process to get it right the first time. Hiring is a dangerous game. It's the most important thing you can do. And we put together a comprehensive guide so you can get it right and get the people you need. Do we have YouTube, Matt? Check out our YouTube channel. Subscribe to the YouTube channel. It's sad. We need subscribers. We need love on YouTube. Go to YouTube, KeyHire Solutions, and subscribe to our channel as well. Our next show, I know we have something really cool coming up. And we were talking to Paul Pelosi and about his business. And what is the name of it, Matt? Do you remember? Escapes me. I'm gapping out. It's called... Anyway, we'll be sending out some information about it, but it's going to be awesome. Paul's a great guy, and it should be a super interesting conversation, and it's a great resource for business owners to bring in entry-level employees, especially kind of in the professional side of the business. Super affordable and a great way to source entry-level employees with education and some good backgrounds as well. So until next time, we'll see you in 2 weeks. Stop grinding, start growing. Thanks for tuning in.